Hello friends, welcome to my channel. This is a girl Mercy. If you're a returning subscriber, I appreciate you. If you're new to this channel, please click the subscribe button, share this video, hit the notification bell so that whenever I drop a new video, you get to see it and also benefit from the information I'm sharing. So today I'm going to continue on the series on matrimonial proceedings in Nigeria. Specifically, I'm going to talk about how to prepare the verifying affidavit and the importance of the verifying affidavit, and also generally on what the petitioner will prove or needs to prove to establish the fact that the marriage has broken down irretrievably. To start, I will say that in preparing a notice of petition, the counsel, whoever is involved, must be diligent in ensuring that it is prepared very well. I've in the earlier video, which I'll link to this video, I've stated that what a notice of petition should contain and the subheadings wherein the issues, the facts will be pleaded, will be stated to show that this marriage has broken down irretrievably, and the grounds upon which the dissolution is going to be based upon will also be stated, so that the facts stated in the notice of petition will correlate and corroborate the grounds upon which you're bringing the petition. So a verifying affidavit is a very important document that must accompany the notice of petition. Now, most people do not know that a verifying affidavit should not be headed separately. After you have finished your notice of petition, the verifying affidavit should be a continuation of your notice of petition. It should not be headed separately, like in the High Court of so. No. You don't head it separately. It's a document that comes along with the notice of petition in the same page. It has to be at the foot of the notice of petition. At the end of what you have finished writing your petition, then the verifying affidavit should be headed verifying affidavit. Then you start the affidavit. It should not be in a separate page. It should not be headed separately. Most people that have done this have had cause to face objections, and when objections are raised as to the incompetence of the petition, the court will read, because it has been stated, it is provided for by the rules, that a verifying affidavit should not be a separate document. So when an objection is raised to the fact that the verifying affidavit is in a separate document, then the objection can fly, and your notice of petition can be struck out as being incompetent. Now, in the case of a celebrated case of Unebu and Inebu, please have to read this smart case. It explains this very well. It's a 2004 reported matter. 11 Nigerian Weekly Law Report, part 884 at 332, at page 332. In this case, that's where the and other cases, but this is a very important, the locus classicus on this issue, on the importance of a verifying affidavit and what it should contain, and how it should be a continuing document and not a separate document. Now, section 6 sub 3 of the matrimonial causes rules provides that the verifying affidavit shall be contained in the same document as the petition and shall follow at the foot or end thereof. It should not be a separate document. Also, look at an old case too that relates on this, on modern against a modern and another. It's a 1966 matter, Nigerian Monthly Law Report 288. So these cases, emphasize on the need for the verifying affidavit should be an integral part of the petition and not a separate document. Also, remember that the verifying affidavit must be deposed to by the petitioner. It should not be deposed to by counsel. No, it should be deposed to by the petitioner. This is they're verifying the facts as stated in the notice of petition. That is what verifying affidavit is all about. It is verifying the fact that all I have stated in my petition is correct and is true. I'm the petitioner. That the facts are deposed in the notice of petition is true and all of that. That's just the essence of a verifying affidavit. And you know that a verifying affidavit is mandatory. It must accompany a petition. Any petition without a verifying affidavit is incompetent. Also, don't forget, in preparing your notice of petition, the marriage certificate should be an exhibit. If the petitioner does not have the original document, then it has to get a certified true copy. I've seen cases where lawyers come to court with a photocopy of a marriage certificate seeking to tender it. It cannot fly, because what the court requires is the original or the certified true copy, because it's a public document. So don't make this mistake. If the petitioner for one reason or the other is not able to produce the original marriage certificate, then you have to go to the marriage registry where the marriage was performed and then get a certified true copy. I'm going to do a video on marriage under the act and customary marriage, and what with that church marriage or church wedding. It's a very important, because most people do not know the difference. Though some lawyers do know, but some lawyers also do not know the importance and the difference or the characteristics of these types of marriages, and the what they stand, their stand, when you just oppose it with the law, and peradventure what there is need for dissolution, which court to approach. Okay, I've talked about the verifying affidavit. Also, don't forget that Order 5, yes, Order 5 Rule 10 sub 1 of the Matrimonial Causes Rules also speaks on the fact that the verifying affidavit is very mandatory, very mandatory. So I've talked about Order 5 Rule 10 sub 1 of the Matrimonial Causes Rules. I've also talked about Section 6. I've talked about Section 6 sub 3(2). Yes, so please look out for this once, and it's very, very important. Another thing I'm going to talk about is what the petitioner ought to prove. Now, it's not about writing the problems, what led to you wanting to divorce your wife, or the wife wanting to dissolve the husband. The petitioner must plead and prove it that the marriage has broken down irretrievably. In giving evidence, the petitioner must give evidence as to that fact as contained in his petition and the grounds which it has tied those facts to. That is, those grounds contained in Section 15 sub 2A to H, those grounds for dissolution. I'm going to dedicate a video for the grounds for dissolution. But whatever fact that is contained in your notice of petition must corroborate, must be linked, must be tied to one or two of those grounds. Now, if all the facts you have stated with respect to your notice of petition has nothing to do with those grounds, the petition will be dismissed. So whatever story or time must be tied to one or two of those grounds. Now, the onus is on the petitioner to satisfy the court of the existence of those facts as outlined in Section 15 sub 2A to H. It is on the petitioner to prove it. Now, where a cross petition has been filed by the respondent, the court has a duty to dissolve the marriage on the grounds proved by the petition, and also in the cross petition. Cross petition is more like a counterclaim, is an independent suit on its own. If the petition does not fly, the cross petition can suffice. So friends, I think I've done so well in this video, and I want you to, if you didn't get anything, at least the part on the verifying affidavit, very important, very, very important, because objections have been raised on this issue every day, and most people do not know that it's important that the verifying affidavit is not headed separately. It is a continued part of your notice of petition. And I know that this information will help you in your practice, because Lawyers Info Hub is here to give you tips that will make you an excellent lawyer, to excel in all you do. Please, if you have not subscribed to this channel, please do share this video to your friends. Tell them about Lawyers Info Hub. And I'm here to give you out tips to help you function exceptionally.